Good morning, Ms. Holderness.
Good morning, Chief Justice. Good
It's
morning,
an
Commissioners.
unusual name. I've never heard of this name before.
It is an unusual name, Chief Justice. I understand there's only a few of us in the country.
Really? Does that not feel lonely? How are you?
I'm well, thank you, Chief Justice. How are you?
I'm fine, thanks. Okay, let's do this. You are a member of the Cape Bar.
I am.
Have been for 20 years?
Yes, approximately 20 years with a very brief sabbatical, Chief Justice, but otherwise uninterrupted for 20 years.
All right. But before you joined that bar, you did a number of things which start with your academic career. You have 3 degrees.
I do.
2 from Rhodes, 2 legal ones from Rhodes, and an MBA.
That's correct.
Why did you decide to study for an MBA?
Chief Justice, I did my articles and 1-year post-articles at Buchanan Boys. I always had a vision from a very young child to be on the bench, and I found myself somewhat disillusioned with the attorney's profession, and I felt that I needed to have a little bit of distance and different experience before I joined the bar. So I decided to do an MBA to gain commercial experience, and thereafter just to work in corporate briefly before taking up chambers at the bar. Yeah. So that was really my thinking at the time.
All right. Well, your CV reflects that after you did your articles, you worked in the magistrates' court in a few districts in Cape Town. For how long was that?
Chief Justice, I didn't work specifically in the magistrates' court. I appeared in
most
of the magistrates' courts throughout the Cape Town as a candidate attorney, but I didn't take up any role as a magistrate.
Yeah, I found that a bit confusing. Okay. So you went on to become a professional assistant, but then you say you became disenchanted with the sidebar.
Yes, indeed.
And
my vision was always go to the bar and ultimately to, if circumstances permit, be elevated to the bench.
You were a management consultant for KPMG Consulting?
Yes, in Johannesburg, Chief
But for
Justice.
a brief spell. Was it a year?
It was approximately a year.
Okay. And then you volunteered at the Red Cross Children's Hospital.
I did.
Very commendable.
Thank you.
And then you did your pupillage and went to the bar.
Yes, Chief Justice. I did my pupillage in Johannesburg at the Bridge Group in Sandton.
What kind of practice have you run as an advocate?
Chief Justice, I first started off with motion court work. I think I was involved very briefly in one pro bono matter, but by the time I started in 2004, pro bono work wasn't something that people were starting out with. So I found myself mostly in unopposed motions, and I was fortunate to build up a fairly busy motion court practice, which then developed into also dealing with a number of opposed motions and civil trials. So it was a generalized practice. I think I was hoping with some commercial background that I would be brought into commercial matters and big junior briefs. That didn't quite materialize, so I tended to run all of my own matters. And I realize now that it perhaps would have been much better in the long term to try and follow a track of more public law work, but that wasn't the path my practice took. I found that I was doing increasing amounts of family law work, which is engaging and stimulating work, but I was hoping to not let that be kind of the main thrust of my practice, but that ended up being towards my later years at the bar, much of the work that I was doing, curatorships, family law, and then some civil trials, general commercial work, property law.
Okay. Well, you've achieved many other skills. You ran arbitrator with AFSA since 2016.
Yes, Chief Justice.
And with the Commercial Property Tribunal.
That's correct.
What happens there? What's that about?
Chief Justice, I was invited. I'm not sure of the exact year. I do have notes here.
Well, your CV say 2016?
2016, yes. So I was informally approached and asked if I would be interested in joining the tribunal. I then had to pay for my trip to Johannesburg and do, I think it was a 5-day course through the University of Pretoria to qualify as a commercial property arbitrator. I was only ever approached to be an arbitrator on one occasion, and that matter didn't run. So unfortunately, it didn't bear fruit. I did do the course, and I am still part of that tribunal, but I've never had a full arbitration over which I've presided. In respect of the Commercial Property Tribunal, I have resided as an arbitrator in other matters, and in fact, I'm presently on a tribunal panel with a retired judge of the SCA and a female silk from Johannesburg. So I have been an arbitrator in other matters as well, but
All
not for
right.
the Commercial Property Tribunal.
All right. And you are also an accredited mediator?
I am Chief Justice.
Okay. You have undergone the aspirant women judges training course run by the South African Judicial Education Institute,
Yes, I went
the advanced course.
the advanced aspirant judges training through SADJ. And then I also, prior to my first acting appointment in 2015, I went to Johannesburg to attend the acting judge workshop run by, or it was convened by Les Morrison SC.
All right. You have also acted as a small claims court commissioner
Yes.
for 3 years. Okay. When did you start acting as a judge?
My first stint was in 2016 in the 4th term. I then did 3 consecutive stints, Chief Justice. So I did the 4th term of 2016 and then the 1st and 2nd terms of 2017. Sorry, if I could just check my notes. And then my next stint was in yes, the 1st and 2nd term, and then the 1st term in 2018. When I finished my 3rd term in 2018, Chief Justice, I had a long-running criminal trial, and I unfortunately don't have a record of the number of weeks that I sat as an ad hoc acting judge in that criminal matter in order to finalize it. It ended up being, it was in the media, it was a considerably more complex trial than perhaps I envisaged, but I don't have a record. But I know that that was several weeks. Thereafter, I acted in 2023 in the 4th term, and I was invited again to act in 2024. That was for 2 one-month periods, and then for a further 3-week period in June 2024.
And during those acting stints, one says from your judgments that you've sat in a wide spectrum of cases.
I have, Chief Justice, yes.
And you've written about 58 judgments.
Chief Justice, I made an error here, and I have sent through to the JSC, and I apologize, only on Sunday. When I was going through my judgments in preparation for my interview, I realized that I'd actually written quite a few more, and I made a table of a full list of the judgments, which included the judgments which I've handed down subsequent to my application in June. On my calculation now, the number of written judgments I've handed down is 73. That does not include any leave to appeal judgments. I didn't understand that those should be included. If those were to be included, they would probably be approximately 15 to 20 over the course of those 60 or so weeks that I've acted. But my full written judgments, excluding extempore judgments, obviously, which I haven't included, and leave to appeal, are now 73.
Okay. And at least 3 of those judgments have been reported.
That's correct, Chief Justice.
Okay. And in respect of those that have been taken in appeal, you were upheld?
Yes, I was. So none of them have been overturned, Chief Justice.
Okay. Acting Judge President Goliath, do you have questions for this candidate?
Thank you, Chief Justice. You have acted intermittently 2016, 2017, 2018, and then you went back to your practice, and then you came back 2023 and 2024. How did you find your growth as an acting judge, having started in 2016 and where you are now?
I think every acting stint, acting judge president, has been different. I certainly feel that I have grown as an acting judge in terms of my command of the courtroom, my confidence in my abilities as an acting judge. In my initial stints, I did fairly long-running criminal trials, and those were a great experience for me as an acting judge, but because Acting Judge President, you decided not to allocate criminal trials at this stage to the new acting judges. Certainly when I was appointed, I was then privileged to have a number of very interesting and somewhat complex civil applications and civil trials. I think on my calculation, during the period in which you appointed me in 2023 and 2024, I did approximately 6 or 7 civil trials. So I was able to do a number of civil trials, which I hadn't done nearly as many in my initial acting stint, so that was a great experience. I had more time in the motion court, more time in the urgent court, criminal appeals, so I feel that it's really broadened the experience which I've had as an acting judge.
So where exactly, what exactly are your strengths in adjudication? Is my understanding correct that it would be commercial law?
Certainly, Acting Judge President, I do believe that I do have strengths in commercial law, both from my MBA and from my experience in civil matters. I certainly have strength in family law matters from my time at the bar. And I have a keen interest in criminal matters, although not wide-ranging experience other than the appeals that I've done and the 2 criminal trials that I've done. But the criminal trials which I did do were both very serious criminal trials resulting in life imprisonment, rape and murder matters. So I feel like I gained a great deal of experience in those matters too.
The workload is quite heavy in the Western Cape High Court. How did you cope with that workload?
I found that for me preparation was key, Acting Judge President. So what I would do is, as soon as I received the file, if I wasn't in court that day, is I would go through the papers carefully in the authorities, try and prepare a chronology, so that by the time I was in court, I was often optimistic and thought I could hand down an ex tempore judgment, but I think particularly in your acting days, that takes a fair deal of courage. So even if I didn't end up handing down an ex tempore judgment, also because once you've heard the oral argument, your kind of prima facie view is often disturbed, I then was well prepared to start drafting the judgment when it came time to doing so. So that was how I would handle the pressure. It certainly is a case of just putting in the long hours. I do recall in early times of my acting judge when my youngest daughter was only 4, and she said to somebody, "I used to have a mom and now I only have a judge." And that was what the long hours involved.
How did you find the Western Cape, the environment in the Western Cape High Court as an acting judge and support provided to acting judges by permanent judges?
I've always found it to be a collegial environment. When I first acted, the tea room was still open and judges were sociable, met at tea time. I was always struck by the fact that acting judges were treated entirely as equals by the permanent judges. Once you were an acting judge, you were a judge and you were treated as such. By the time I returned in 2023, it was good to see that the tea room was back. I tried to go as much as possible and socialize with colleagues, many of whom I still knew from 2016. So I found it to be a collegial environment, and I've always enjoyed acting there. I've also found very much that it's an open door policy. If one needs advice or to bounce off a view or a judgment, that colleagues' doors are always open. I've found that always to be the case.
It appears that you are an experienced mediator. Is there a role for mediation in the adjudication of matters in our courts, specifically the high courts?
I think there is, Acting Judge President. The one thing I'm never certain of is how the judge's role fits into this. I think the judge is not there to act as mediator, but I think the judge certainly has an oversight role to ensure that parties and their legal representatives don't merely pay lip service to Rule 41A, and that they comply with the prescripts of that rule and make sure that genuine attempts are taken to resolve matters prior to resorting to litigation, so that litigation is the last resort. And my sense at the moment is that litigants not litigants, but legal representatives aren't taking that rule seriously. They are not doing what they should be doing. And certainly it would be in the interests of the judiciary in terms of workload and in the interests of litigants that matters are properly mediated, or that proper attempts are made to mediate matters before they end up in court.
Is there any specific areas where you feel you did not get sufficient exposure in during your acting stints?
Not so far, Acting Judge President. I've been I was trying to think about which matters I haven't been in. I've been in matters involving competition law, administrative law matters. It's not my specialty at all, but I have been in a number of administrative law matters, criminal appeals. I think the one type of matter I don't recall doing, unless it was very early on, is a bail appeal. But that was really about all I could think of that I haven't done in terms of, and I haven't been involved in a tax or shipping matter. But otherwise, I do feel that I have had broad experience of the various matters that come before the court.
Thank you, Chief Justice.
Thank you, AJP.
Thank you, Acting Judge President.
Commissioner Boshoff.
Thank you, CJ. Good morning.
Good morning, Commissioner.
So given its location in the Western Cape with the seat of Parliament there and obviously provincial government, the metro and the various municipalities, administrative law makes up quite a heavy part of the civil caseload in this division.
Indeed.
So I'm going to ask you two technical questions regarding some common themes that I'm becoming more familiar with just from my own experience in my role. So what we're seeing these days is a growing tendency in these so-called Part A and Part B applications, where Part A contains an application for an interdict or an interim relief pending the hearing of the Part B and final relief, where the Part B deals with a judicial review application. Applicants are increasingly relying on a general right to review or general right to fair administrative action or a fair procurement process in terms of Section 217 as the basis for establishing a prima facie right in terms of interim interdicts. What is your understanding of that reliance, and is it appropriate? And if so, why or when or why not? You just mind engaging on that?
It's a complex one because I think it's touched on in Tassima and Outer, but I think parties believe that if they meet the interim, the ordinary requirements for an interim interdict, the first being a prima facie right, I think there is a perhaps misplaced belief that if they can show that they have a prima facie right to review an administrative action, that is sufficient to establish the requirements for an interim interdict. And my understanding of the case law is that that's not necessarily so.
Sorry, can you just speak to the microphone? We're struggling at this end.
My apologies. My apologies. Thank you, Commissioner. Sorry, my understanding or the complexity in this is that I think parties perhaps in review matters mistakenly believe that in order to satisfy the requirements for an interim interdict, it is sufficient to show, in order to prove the first requirement that they have a prima facie right to the relief they seek, to show that they have a prima facie right to review, and that isn't sufficient. They would need to show that there would be irreparable harm were that interim interdict, so the Part A of the application, were that not to be granted, that the right to review would not suffice, that there would then still be irreparable harm. And my understanding is that that's a separate requirement. It's not sufficient to merely show that they have a right to review. They must also show that that right would be irreparably harmed were the interdict not to be granted, assuming that the other requirements for an interdict are granted. Are satisfied.
Yes, and I mean, as Outer dealt with the so-called clearest of cases where the infringement is so blatant and gross, or perhaps there was fraud involved, etc. Yes. Okay, thank you. And then the second question is just the concept of so-called reactive or collateral challenges. What is your understanding of them, and can organs of state rely on them, or raise them, rather?
Thank you, Commissioner. Not being an administrative law expert by any means, my understanding of a collateral challenge would be where they raise a challenge to administrative action which is not before the court. And the difficulty with that then is that the court it's not seized as it would in a Rule 53 review matter. It would be seized with a record. It would have the correct parties before it. Now it's required to determine a collateral challenge, for example, in criminal proceedings where an accused is challenging the validity of a statute. They would then be required to determine that almost on a review basis without the review being properly before the court. I understand it to be permissible in very certain circumscribed circumstances, where the court would then have to look at, for example, if it was the organ of state bringing this challenge, that it's a full explanation, and obviously within the peculiar circumstances of that case, but there's a full explanation as to why they did not bring a full or ordinary review application to challenge that impugned decision in the ordinary course, so that the court then was in a position to determine it properly as it would in a review. So, to answer your question in a rather long-winded way, I believe it may be permissible in certain circumstances on the basis of, for example, Tassima, but the court would have to very carefully consider if the circumstances were such that the organ of state were justified in bringing a collateral challenge without the benefit of the necessary documents and review record.
No, thank you very much.
Thank you, Mr. Brasher.
That's all from me. CJ.
Thank you, Mr. Bishop. Commissioner Matolo Lebu.
Thank you, Chief Justice, and good morning, Advocate Holderness.
Good morning, Commissioner.
From your questionnaire, you seem to have been lucky in doing all the matters, the commercial matters, insolvency matters, that's what you said, property matters. And you indicated that you have been working with highly respected senior counsel, and you named them. But besides you being a small claims commissioner, I don't see any mention of your participation in transformation and skills transfer. Or in all these matters, have you ever roped in black juniors, black female juniors? I don't see that. Can you just advise me of that?
Thank you for the question, Commissioner. Commissioner, the nature of my practice has been such that I haven't brought in juniors, full stop. I've run a practice, so up until the time when I first started focusing on trying to secure acting appointments, I'd only been at the bar in 2015 then for about 11 years. At that stage, I didn't have a practice where I could rope in juniors at all. I didn't work with big firms. I've not yet to have a state attorney brief in the history of my practice, despite having my name on the panel. And the matters that I had were from small to medium firms, often matrimonial law or smaller civil matters, and I didn't bring in juniors. It is not a case that I brought in white male or white female juniors. I simply didn't have juniors at all. I'm aware of this as a shortcoming, and I sought to get involved in training. So I trained pupils for a number of years in the law of evidence. I also was involved as an adjudicator in the UCT moot competitions. And when I realized that I certainly hadn't and was not really in a position to meaningfully assist in the transformation of the bar, other than through mentorship, and I have included in my application, I hope the commissioners have had sight of a number of letters of black female attorneys and advocates and black male attorneys and advocates that I have mentored informally from my very early days of practice. I then, when COVID hit and things slowed down a lot, became involved as a founding director of Flamingo Sanitation. And my thought there was, whilst it has nothing to do with the legal profession, is that transformation in South African society is required at all levels of society. And Flamingo was something where it had the potential to transform the lives of the poorest, specifically women and children in our community, by providing a sanitation solution which would keep them safe, which would provide them with dignity, and which would also improve the environment in which they live. It's an NGO, there is no profit involved at all. I've contributed my own money and hundreds of hours of my time going into the community at Joe Slovo, meeting with people on the ground, learning about what their needs are, and developing a prototype toilet, which we are now seeking to pilot. September last year, I presented at the Africa Climate Summit on Flamingo Sanitation in Kenya. So it's a project that I hold very dear to my heart, and it is the active manner in which I've tried to contribute to transformation, albeit not through the legal profession.
My problem is that from your questionnaire, you seem to be having done good work. And in a South African context, especially from a woman, I would have expected you at least to rope in some black juniors to be part of these matters that you are doing. So I'm actually quite disappointed. Your transformation initiatives don't talk to the transformation of the legal profession. I just wanted to mention that.
Thank you, Commissioner. That's well noted. Thank you.
Follow
Follow
up,
up?
CJ.
Mr. Boshoff?
I thought it was a draw. All right. Sorry, just to clarify and follow up on that question. So I understand what you're saying is that you've never been in a position, you've never led juniors,
No.
full stop. And who would normally make that decision to draw in a junior when you are briefed yourself as a junior advocate?
It would be, because I haven't done it, it's a difficult one to answer. It would often be the decision of the attorney because, of course, they would have to determine if there were sufficient funds to draw in a junior if it were not a pro bono matter. I suppose if a senior junior felt that a junior was necessary, they would try to motivate it to the attorney and say, I do need assistance. But the nature of the matters, the trials I've run, I ran them myself and I didn't require the assistance of a junior.
And if I understood your engagement with, I can't remember if it was the Chief Justice or the AJP, but I mean, I also got the impression that you yourself have very seldomly benefited from being drawn in as a junior by a senior in silks.
Yes,
All right.
I haven't.
Thank you.
Thank you.
Commissioner Mgwetho?
Thank you, Chief Justice. I will ask you about transformation in a moment, but I need to first deal with administrative law. Your outer answer I've got no problem with. I think it's actually correct. But I was very confused with your collateral challenge answer. So maybe let me ask it differently. If an organ of state granted a tender to a company, and then it then decided that it doesn't like the way it went about it, it wants to set it aside, what is the legal basis on which it can do? It can do so. There is an administrative challenge under PAJA, which is available. There is a rule of law challenge under legality. How would they go about it, and how would you look at it as a judge?
Commissioner, am I understanding the question correctly that it would be the organ of state which is seeking to set aside its own administrative decision or tender decision?
Yes, it has made an administrative decision to grant a tender. It doesn't like it anymore. It wants to get out of it. What I'm asking for is the pathway.
My understanding is that it would not be entitled to do it under PAJA because of the Constitutional Court's decision in Gajima. It would have to go...
No, you don't need to go further. That's sufficient. Now, the issue of transformation is raised by AFT.
Yes.
They're saying we must ask you, what have you done for transformation at the bar? There are many ways of doing transformation. One is to bring juniors. You've explained that you didn't have a chance to. That's fine. We're not going to hold that against you. But there are also other ways, participating in committees, promoting the broad interests of the black membership, female members at the bar, etc. So have you been involved in those types of transformation initiatives?
I recall I was involved in subcommittees in my earlier years of the bar. I sat as a member of the Bar Council in, I think it was 2018. So that I have done, and then the training which I've mentioned. I've been passionate, not in a formal capacity, Commissioner, but certainly in promoting black females at the bar, a number of which I know and am friendly with. So an example would be, and perhaps this doesn't raise to the bar which you've set, but whilst I've been acting, and then once I'm off the bench, I will say, so-and-so, a black female junior, appeared before me in this business rescue matter. And I'll approach white male silks who are doing the majority of that type of work. And I will give them a list of the names of these people who appeared before me, or these women, who have been excellent in terms of their written argument, their oral argument. Because a lot of the, sorry.
Now, you see, the reason I'm asking is because when I look at your letters of support, it's actually quite an impressive list. The first one is from Karisha Pillay, who's a senior counsel, black female from Cape Town. Then there is a Mr. Unati Shasha, who works for the government but speaks very highly of you. And then there is, I think, Mbebe, attorneys, Unati Mbebe, also speaks very highly of you. And then there is a fellow from ENS, A black attorney from ENS.
It's a female.
Is it a female?
Mame Moateng, yes.
Amoateng.
That's correct.
Also speaks very highly of you. A black advocate from the Cape Bar, Gugulethu Samkange, who also speaks very highly of you. So it does look like at an individual level, you actually pay attention to individuals and you try to support them and to promote them.
I endeavour
It
to
may
do
be
so.
that at an institutional level you are lacking, but I think individually you pay attention.
Thank you, Commissioner. I endeavour to do so, but I accept that I, at an institutional level, could have done more. I accept. Thank you, Commissioner.
CJ, may I follow up on that transformation question? Good morning, Ms. Holderness.
Good morning, Commissioner.
Yes. You've had a discussion about your inability to use your position at the bar to support juniors, female, black. Now, the point, at least for me, about inquiring about your transformation background and credentials, if you like, is to try and determine what kind of judge would we be recommending or advising to be appointed? Who are we putting onto the bench? And is there anything in your judgments? You have quite an impressive list of judgments since you acted, about 79, I think you say. Are there any particular judgments which would say that you're happy to discuss with us, that you would say reflect your views about transformation, not so much of the profession, but even the law itself?
Thank you, Commissioner. I've endeavoured in my judgments to, and perhaps it's transformation within society, to be very mindful of the constitutional values which all judges are required to uphold. So from the very start, for example, in the first criminal matter, which I did, I investigated prior to that matter, or it researched to quite a great degree prior to the matter, the principles of restorative justice. And my thinking, and I applied those principles in that criminal trial. And my thinking there was to try and, based on our constitutional values, let there be some peace and closure for the parties, both the accused as well as the victims' families. Similarly, in eviction matters, which I've dealt with, I've tried very hard to craft orders that, where it has been necessary to follow through with an eviction order, the rights of the occupiers subsequent to the eviction are protected as far as possible, and their position improved as far as can be allowed within the prescripts of the law. In matrimonial matters, similarly, I've tried to be as proactive as possible in ensuring that the rights of the children, in terms of Section 25, are adequately protected. So in terms of transformational at a society level, I'm very mindful of that, because I think that it's a sacred position that a judge holds to uphold those values. And it's not a question of activism, it's a question of making sure that you do what is necessary to protect the litigants who appear before you, particularly when it's unrepresented litigants, and to fulfill your mandate of upholding those principles to the best of your ability.
Thank you, Ms. Holderness. Thank you, CJ.
Thank you, Commissioner.
President Molemelo.
Yes, thank you, CJ. Good morning, Ms. Holderness.
Good morning, Commissioner.
I'm over here.
Oh, there, sorry.
Yes. I see that you attached only one judgment on criminal law, and it's a judgment on sentencing.
Sentencing.
Is that correct?
That's correct, yes.
I don't see anything on the merits, in other words, relating to the verdict. Was this a plea of guilty?
Sorry, no, I should have, Judge President, I should have annexed it. No, it wasn't. It was there was a very lengthy judgment on conviction. So that was for the first, the one judgment. It was a rape and murder of a 14-year-old boy. It was a full trial, and then there was a conviction, and life imprisonment was imposed. But I wasn't certain how many judgments I could annex, and as I recall, that judgment on conviction was close to 100 pages. So I specifically annexed the judgment on sentencing because of the application of restorative justice principles, but in hindsight, it perhaps would have made sense in that matter specifically to also include the judgment on conviction on the merits.
Yes, you'll accept that, not including the judgment pertaining to the verdict. deprives us of assessing how you arrived at the decision in terms of the reasoning.
If it would be at all possible, I could certainly place that before the Commission, but I realise just how time restricted the Commission is. I apologise for that oversight, Commissioner. I should have placed it before the Commission.
Yes, I think earlier on you indicated to the Chief Justice, or was it to Judge Goliath, I don't remember, that you did you conducted two criminal trials.
That's correct.
And the judgment in respect of the other matter?
That was also a full judgment on the merits, Judge President. It was also a conviction that was on murder.
Yes. As I understood your responses, it would seem that your practice was mainly civil.
Yes,
in
indeed.
nature.
And I recall, if I may, prior to first acting on the bench, I consulted extensively with colleagues and retired judges to try and get as much information on criminal procedure as possible prior to starting my first trial, because I hadn't done any criminal work at the bar at all.
Yes, okay. So you haven't done any criminal work at the bar, and during your acting stint, you conducted two criminal trials?
That's correct. Sorry, if I could just say, I did briefly do a pro bono matter right at the beginning of my time at the bar, but it didn't actually run. So I became involved in it briefly, and then I didn't continue with it. And after that, I didn't do any criminal matters at all.
All right, thank you. And did you sit alone or with assessors in this matter?
No, we were not appointed assessors at that time, Judge President, so I sat alone.
Okay, thank you very much. Moving on now to the civil aspects, have you had occasion to consider an application in which an anti-pillar order is sought?
Yes, not recently, Judge President. I think that I had one in chambers in about 2017, so in one of my first acting terms.
Yes, and can you tell us about the requirements that an applicant has to satisfy?
I don't recall them entirely offhand, but as I recall, they would have to, of course, satisfy the requirement of urgency. They're granted invariably in chambers and ex parte, so they would have to satisfy that if essentially the purpose of it is to preserve evidence, and that if the order were not granted ex parte and on an urgent basis, there's a reasonable apprehension or real possibility that the evidence would be destroyed and that the matter could not be decided. And then they would need to also make provision for a supervising attorney or somebody similar to execute the order. So that's as best as I can recall, Judge President.
Is that the kind of order that you granted
Yes,
at the end of it?
Yes, it was. And I can't recall specifically what the evidence was. I think it was all electronic evidence or hard drives. But yes, that was the order that I granted in chambers.
Okay, thank you very much, Ms. Holderness.
Thank you, Judge President.
Thank you, CJ.
Thank you, Commissioner Moiman.
Thank you, Chief Justice. Good morning.
Good morning,
To yourself and the commissioners. Good morning.
Good morning, Commissioner.
Just one question from my side, because in your questionnaire you raises your areas of interest and a range of matters where you have traversed, which speaks to areas like criminal law, commercial law, public law. It's silent on constitutional law, so I just needed to get comfort that when matters that are constitutional are brought before you, you'll be able to know what are the powers of the courts when it comes to constitutional matters.
Yes. Thank you, Commissioner. Yes, it certainly is a gap in my experience as an advocate, and as I mentioned earlier in the interview, it's a regret that I didn't pursue that field of law because it's a fascinating one. I have done a number of matters. I think one of the judgments I included was Abet versus Petro SA, which was a procurement review. I've recently sat with Justice Saldana in a valuation appeal board matter, which was, we had the top advocates in the country, some of the top advocates in the country before us in very, very complex valuation appeal board review. I suppose in a number of matters, any matter involving a child, evictions, they all have constitutional themes in them. So I certainly feel that where I have shortcomings in experience, that I'm able to do the necessary research to get my head around the facts fairly quickly, and always to seek the advice of those who are more experienced in these matters than I am, where I feel that I'm not quite, or I'm out of my depth. So I'm not scared of doing the hard work that's required to bring myself up to speed with whatever act or statute applies, to read vast volumes of records, and to do what is required. I do believe that I have the ability to do so and to handle matters of that nature.
Thank you, Advocate. Thank you, Chief Justice.
Thank you, Commissioner.
Commissioner Marumokge?
Thank you very much, CJ. Good morning, Advocate.
Good morning, Commissioner.
I think sometimes when one looks at some of the judgments that are coming out in South Africa, especially by some of the acting judges, it appears to me that perhaps maybe the issue of the rules are not taken as seriously as they should. And I'm asking this question on the basis of that, and I'm not accusing you of not having had taken any rules seriously.
Yes.
There are times when somebody applies to appeal or notes an appeal and that they are granted leave to appeal. And on the eve of the appeal being heard or in preparation of the appeal, evidence that did not serve at the lower court surfaces, and they want to rely on that evidence. Under what circumstances can they be permitted to lead that evidence, if at all?
So I think the paramount consideration would be the interests of justice, and to ensure that there's a full hearing of the matter on appeal. It would only be my understanding is it would only be in exceptional circumstances, and there would have to be a full and adequate explanation as to why that evidence was not placed before the court of quo. And the appeal court determining whether or not the application to admit further evidence should succeed would look at that and the reasons for why that evidence has only come to light just before the hearing of the appeal.
Thank you very much. Thank you very much, CJ.
Thank you,
Thank
Commissioner.
you, Prof. Commissioner Trollip?
Thank you very much, Chief Justice. Advocate Holderness, Commissioner Ngukai-Topi said we won't hold it against you for not introducing juniors into your cases against an explanation of a developing practice that didn't have the scope and capacity to do so. And then he made mention of a list of commendations by black attorneys, which speaks of transformation in action and empowerment in action. But you did say that you accept that you could have done more at an institutional level. What do you plan to do once appointed as a judge at an institutional level regarding transformation?
Thank you, Commissioner. I think that when it comes down to brass tacks, it's all about briefing patterns, Commissioner. And unfortunately, in our division, as I'm sure in many divisions in the country, despite numerous efforts by the bar councils and by associations such as NADEL, BLA, AFT, it seems the briefing patterns are still very much skewed, particularly in bigger matters, towards white silks. I often have matters where the parties before me are represented by a white male senior and a white male junior, and there's not even an attempt at transformation. It's a difficult issue as to how the bench can actively become involved in changing this. There has already been the matter in Johannesburg, the Perry-Fore matter, where there was a degree of judicial activism, and perhaps some form of judicial activism is now required in more matters in order to ensure that there is sometimes an explanation for why parties are briefing the same male white silk advocates and the same white juniors over and over. Because it's certainly, despite all the attempts by the Bar Council, there doesn't seem to be marked change. It is encouraging, however, to see, particularly in our division in the motion court, there are a number of black females who seem to be getting a lot of the motion court work and the bank work. But that needs to transform beyond the 0 to 5 years so that those black females are retained and can build practices where they will reach silk status and hopefully eventually some of them be elevated to the bench. So I think it's something that the bench needs to be aware of. The bench needs to engage with the various organizations, engage with the attorney's profession, and find out what steps or measures can be taken in place so that there can be real on-the-ground transformation of who receives briefs. And of course, the state attorney is included in that, but there's now the tender process, and that's something quite different. But I think certainly the bench has a role to play. How that role may pan out remains to be seen, but it is something I certainly would be passionate in becoming involved in.
Thank you, Chief Justice.
So, Chief Justice, I do want to follow up this point. You see, the problem, Advocate Holderness, is the question is, what do you plan to do at an institutional level, you yourself, now that you're going to become a judge, and that is a very, very big position? There are many things that judges can do to promote transformation. On the extreme side is Judge Motta, who basically refuses to hear a case until a black person appears.
Yes.
And then on the other side of the spectrum, something I used to do when I was active, both teams come with all white males, and maybe there is a black female on the margins. But to ask the attorneys and the advocates, why are there no black people in the teams?
Yes.
Often, by asking the question, you bring shame to the team, and when they next appear before you, there is in fact a black person. You can do that without spectacle. You can do it privately. You can do it at a pre-hearing meeting. But I find many judges don't do that. They just accept all white teams. And then they come to the JSC and they protest about a lack of transformation.
Indeed.
And a sense of disempowerment on their side. So maybe if you can just give us 2 or 3 things about what you will do. If you're going to follow Judge Motta, fine. If you have a different strategy, outline it.
Thank you, Commissioner. One of the things we do have available to us is, in our division as in the others, is that prior to hearing a matter, the parties file a practice note which sets out the names of the counsel and the attorneys. So if one of the things I would certainly consider doing then is prior even to the matter presenting in court, one could call a meeting with the practitioners appearing. And if it is in case of an all-white team appearing in a matter with no black juniors, call the counsel in and say, it appears to me that the racial composition of these teams is unacceptable. And this is something that I would see be addressed prior to the hearing. Because once the hearing has already started, it's very, very difficult, even at least in the early allocation matters, one has some time then potentially to bring in a black junior who could then become actively involved in the matter and not just be there for show, but be somebody who is assisting. By then, of course, the heads of argument are filed, but they at least would be gaining the experience of that. And the leader would be then getting to know them and then potentially bringing them in at an early stage in other matters. So I think that potentially could certainly be one of the steps which could be taken. But I think perhaps also is figuring out how engagements, formal engagements, could happen between the bench and the profession, in whatever form that may take. And by the profession, I mean both the bar and the sidebar, to find out what is, in my view, the larger firms in particular, I mean, they hold the vast majority of the commercial work. The junior black females are getting some state advocate work, they're getting some unopposed briefs. They're not getting, as far as I can see, the bigger commercial matters. If they do, they are there as juniors, but they need to get to the point where they will become the silks. They will become the black female silks leading juniors in the bigger matters. And I think that is where I would try to ensure that that sort of engagement takes place at a level where there's then accountability by the profession and measurables. Because as I see it, as far as I'm aware, that's not happening.
Yes, there is another idea, given that you are now where you are and you may be recommended. In England recently, they require the advocates, when they submit a practice note, to set out which part of the argument will be addressed by the junior.
Yes.
Which forces them to allocate, not just to have it for window dressing,
Exactly.
but to allocate a substantive role to the junior.
Thank you, Commissioner. If I may, just on that, and I think that's a very valid point, and I can recall in one of the very few junior matters where I appeared in Kimberley, I was asked to argue, and it wasn't arranged beforehand, but because I think I was jumping up and down during my silks argument so much, she said, would you like to argue the reply? And I said, certainly I would, and I did. And it's exactly that kind of experience which black juniors need, that they argue, that they don't just sit there and take notes and point out things in the record, they actually get on their feet and get to argue matters. That to me sounds like a very sensible initiative. Thank you, Commissioner.
Commissioner Matorot-Lebo?
Just a follow-up, Chief Justice, I'm very passionate about transformation issues. Were you not part of the GCB when they wanted to kick out AFT in your back?
Pardon, Commissioner, I didn't hear the rest of the question. Was I part of the GCB when?
I'm saying that in your meeting with the GCB, you wanted to kick out AFT. Were you part of it?
Did I attend it or did I
Yeah.
vote for it?
Yeah.
I recall attending it. I don't recall vote. I certainly didn't vote for it.
Okay.
Thank you, Commissioner.
But what is your opinion on it?
I did not support it, Commissioner Gutsobe.
All right. We have no more questions for you, Ms. Holderness.
Thank you, Chief
Unless
Justice.
there's something you want to raise with us, you are free to go.
Chief Justice, there was just one further element which I wish to raise. On my list of reserve judgments, all of my reserve judgments have been delivered, and this is perhaps something which I should have raised with the Acting Judge President, but as you've asked now, it just came to mind. All of my judgments have been delivered within 3 months, save for one that was, I think, a week over, and on average within 2. Shortly before coming for my interview, there was one matter which I recalled hadn't been finalized. It was a very brief RAF trial. I couldn't find the file at first, and I did find it, and I saw that there were not heads of argument. It hadn't been placed on our reserve judgment list because it hadn't been finalized. I was awaiting the transcript and heads of argument. I didn't have a registrar. I had several registrars over my acting stint, recently I think 5, and I then had to email the parties to find out what the status was, and they informed me that heads had been sent to a prior registrar who had not forwarded them to me. So that matter will now be added to the reserve list, and I will ensure that the judgment is delivered within a week. But I just didn't want it to be that I hadn't disclosed that there was that outstanding judgment. That is the only outstanding judgment, and it will be delivered shortly.
Thanks for that.
Thank you.
It is a good addition.
Thank you very much. Thank you, Commissioner. Thank you.
Thank you.
Thank you, Chief Justice. Thank you, Commissioners.